We will start in a minute. I'm only, hoping the numbers to touch 100 before we start.
That is what Andrew was saying, century.
Yes.
You touched 100 yesterday?
No.
No, Santan. I was asking Santan yesterday in the gathering.
Oh.
Pardon?
I said, did you touch yesterday 100? Goenton's lecture?
No.
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 Good. 87?
We were about 60, I think.
So we are already 89.
We should start, Santan, because we should not.
You can start.
I think
Sangeeta?
we should start. Yes, we can.
99.
Andrew is there? He's there?
He is very
100.
much there waiting for you to start.
We have reached
Okay.
100.
Okay. So, a very warm welcome to all on behalf of Nivaran, the mediators of the Supreme Court of India. Nivaran started its journey in 2019 when the mediators at the Supreme Court of India got together and started organizing themselves to update their skills. At the beginning of 2020, Nivaran hosted its first physical event at the Indian Law Institute. And after that, during COVID-19, it organized the first webinar through Zoom, to which it got more than 25,000 viewers through YouTube within a month. Since then, Nivaran has been hosting regular seminars, chats, and summer school on mediation, etc. And now today we have the 21st guest lecture in the lecture series. And the topic is the mediator and the lawyers, friends or foes. As always, Nivaran is taking up the issue predominant in legal practitioners' mind today and places it in front of us. More so when Indian Mediation Act is on the anvil. Today, and mediation going to get statutory recognition. Let me introduce myself. My name is Sangeeta Mehrotra. I am a lawyer by profession, in practice since 1985. In 2011, I took training as a mediator. Until now, took almost 250 hours of professional training as a mediator under various recognized national and international institutes of repute. Presently, I am going through IMI certification process that will make me an IMI certified mediator soon. Today, I am humbled being chosen by Nivaran to host and moderate this session. My co-host is Mr. Aruneshwar Gupta, senior advocate who calls himself as Peace Mediator, promoter of Legal Revolution 5 and Spiritual Revolution 5. He is practicing law since 1976 in the Supreme Court and has wide litigation practice experience in India and overseas. He was Additional Advocate General for the state of Rajasthan in Supreme Court. He was also the chief draftsman of white paper in publishing and printing of judgments using neutral citation and member of Supreme Court Committee on subject categorization. Mr. Gupta has written several articles and made numerous presentations and addresses all over India and around the globe. He has published Understanding Supreme Court Better, 151 Facts You Need to Know, has co-authored Supreme Court on arbitration law and published a translation of Srimad Bhagavad Gita, Lawyer's Perspective. He is pioneer in law IT and is now working on making online mediation available to all those who are seeking the services. Today's topic, the mediation and the lawyer, whether friends or foes, depends on the specific dynamics of the case, the individuals involved, their intent and approach to resolving the dispute. There may be instances where their roles may seem conflicting. This can sometimes create tension or differing perspectives between the mediator and the lawyer, but often during reality checking, such differences vanish. I have experienced that mostly lawyers play pivotal role in bringing the much coveted resolution. Our democratic values emanated from debates and discourses that have always helped Indian society in overthrowing authoritarian tendencies. Litigation is linear, whereas mediation, which places the power to parties, is a holistic approach to reach a resolution. Discourse or Vad Samvad had always been the inseparable intrinsic element of our society. Our natural and desirable condition is harmony, but the predominant Western perspectives focus on freedom as an absence of restraint and on autonomy and individual liberty as the highest goal. The focus is on fighting for rights and liberty without having a peep into the duties and harmonious coexistence. These notions, crystallized in the adversarial system, pervade our legal process and the lives of our lawyers and also the litigants. Most lawyers neither understand nor perform mediation nor have a strong interest in doing either. At least three interrelated reasons account for this. The way most lawyers, as lawyers, look at the world, the economics and structure of contemporary law practice, and the lack of training in mediation for lawyers. It's almost like we are on the crossroad in a dilemma: mediation or litigation, mediator or lawyer. In today's session, we will see if besides this either or situation, can there be a middle path? With this thought of mine, I am happy to announce that in the coming 30 minutes, we will ride through the waves of thoughts, deliberations over today's topic, and thereafter we will interact via question and answer session. And I urge our young participants to make the best of this session. Today, our honored guest speaker is Professor Andrew Goodman from London. Welcome, Mr. Andrew. Professor Andrew Goodman, an intelligent, curious, open-minded communicator, has 45 years of experience as an independent commercial barrister and 30 years as an international consulting mediator, CEDR 1993 batch. He is an award-winning thought leader in the field of mediation, mediation advocacy, and practices in almost 20 jurisdictions, both as a mediator and an IMI mediation advocate, trainer, and consultant. Mr. Andrew holds a number of visiting academic posts and advises governments, bars, corporations, and institutions on conflict avoidance and dispute management systems. By invitation, Professor Andrew has addressed, among others, the Supreme Court of Nepal, the Law Reform Panel of the Supreme People's Court, Beijing, the High Council of Justice, Brussels, the Court of Cassation, Istanbul, and the multi-door Court of Lagos, the Commercial Court Judiciary of Croatia, and the bars of Hong Kong, Singapore, Cape Town, Istanbul, Ankara, Lagos, Bangkok, Dublin, Prague, and Krakow. He is a master of the bench of the Inner Temple and a distinguished fellow of the International Academy of Mediators. Andrew is a director of the UK College of Mediators, convener of the Standing Conference of Mediation Advocates, director of the Association of Mediation Assessors, Trainers, and Instructors, and has been a member of the Bar ADR panel since 2005, the Independent Standards Commission of the IMI, that is International Mediation Institute, and co-chair of its Mediation Advocacy Appraisal Subcommittee since 2011. Andrew is also an AppCam International Certified Mediator and empaneled with the AppCam chapters in India, Australia, Hong Kong, Malaysia, Indonesia, and Nepal. He is the author and editor of nearly 50 books and 12 journals, including Preparing for Mediation, a guide for consumers, and Effective Mediation Advocacy, a guide for practitioners. His wider writing on law also includes 2 legal bestsellers for practitioners, Effective Written Advocacy and How Judges Decide Cases. Andrew, we are delighted to have you here with us today. Enrich us and our audience with your varied expertise and experience that will certainly make us comprehend better the relationship between a mediator and a lawyer, who are not necessarily friends or foes, but rather play different roles within the legal system. Floor is yours, Andrew.
Thank you very much. Thank you for a very warm introduction, which I appreciate. And of course, it is both my great honor and privilege to be able to speak to you today. As you know, when mediators aren't mediating, the very favorite thing to do is talking about mediation. Mediation is a proselytizing cult almost, as it develops around the world. But the most extraordinary thing I find about mediation is that it is not a modern phenomenon, but it is a throwback to ancient cultures and the way in which disputes were resolved before the institutionalizing of those legal principles that we assume are embedded in Western democracies and liberal thinking. The fact of the matter is, I feel inclined to recognize and be very modest about the idea that Southeast Asian cultures and the subcontinent were at the cradle of effective communal dispute resolution at a time when literacy in the West had hardly got going. The fact is that any approach to looking at the relationship between the mediator and the lawyer has got to be couched in the particular context of the jurisdiction in which this field of both process and study is being developed. What I would like to do in the time available is firstly to talk about my approach. Secondly, I'd like to just spend a few moments looking at my own journey in mediation to see whether it's reflective of your own. And then I want to address the question, but I want to address it by putting it in the context of comparative work which has been going on. And I take as my examples the jurisdictions of India to start with, Nigeria, Turkey, Italy, and the United Kingdom. I want to answer the question whether lawyers are indeed the foes of mediators or lawyers are the friends of mediators. And I take as the answer, spoiler alert, that good legal analysis? It depends. And certainly in many instances, lawyers could and should properly be regarded as the best friends of mediators. After all, that is their principal supply of work. Secondly, there are occasions when it's just not possible as a practicing lawyer representing a party to do everything the mediator wants and to intervene in defense of your client's rights and interests. And under those circumstances, you come to a division in the path. You cannot follow the path of the mediator where it conflicts with what you perceive to be the best interest of your client. And that's really where I intend to end up, looking at developments and trying to understand in the wider context whether lawyers should be turning to mediation for the benefit of their clients, and if they are not doing so, why they are not doing so. I also want to spend a few minutes looking at process and the contribution that lawyers should be making. I've always taken the view that this is not an academic subject. And although there is very considerable academic growth and has been over the last 2 decades, really mediation as a whole, I think, should be looked at as a pragmatic subject, in the sense that my own approach to teaching or training, wherever it is in the world, is that of a pragmatist. I think the answers have got to be practical, and I think the answers sit almost in conflict with binary systems of justice that we see in operation around the world, and where lawyers are principally trained. It seems to me that mediation in its modern form is simply a reaction to the strictures of binary forms of justice. And if you think about it, all binary forms of justice are simply founded on the basis that there should be a winner and a loser, that there should be a portion of blame, there should be a finding of fault. And if you have a rights-based system or a rights-based process, it is almost impossible to escape the idea that you are designing a system where 50% of all those who enter into the process will be dissatisfied with the outcome, because that is the mechanism that the process is designed to produce. The problem is, in jurisdictions all around the world, the cost of litigation and the time that litigation takes and the limited outcomes that the litigation brings, and the damage to relationships and the damage to reputation, and even simple things like stress and loss of management time and opportunity cost, none of which are factored into the litigation process as matters to be taken into account by the courts in any event. All of these things suggest in my mind that here is a binary process where it's quite likely perhaps more than 70% of people who engage in the process are sufficiently dissatisfied that they wish they had never entered into it in the first place. And therefore I do take in a good 20% of people who are nominally winners, because if one looks objectively at the overall outcome, I think that is much more likely to be the case. Now, having said that, I also believe I'm a controversialist. Unfortunately, mediation is still seen as a controversial subject amongst lawyers in the many jurisdictions in which I operate and consult. And part of what I want to talk about today is why on earth that should still be the case. Why should mediation be a challenge for orthodox legal practitioners? Why is it the case that the legal educationalists don't have the same foresight as those academic courses that are now fully recognized the importance of alternative systems of civil process. And we need to open up this discussion. And this discussion focuses less on the world of academia, where I think mediation and ADR courses are now firmly entrenched, and they are producing at least 3 generations of lawyers for whom mediation is something to be embraced, something to be recognized as effective and working, and go to the heart of the problem, which are by and large, in my experience, the senior bar and the institutional bar and institutional law societies, where the orthodoxy of training in the past and commercial needs have created a barrier to entry at the point when the young people coming in for training contracts are at their most enthusiastic about the use of mediation, conciliation, arbitration, alternative processes. I think it's also important to take mediation as a generalist. It is true that the various different fields of practice in mediation are such that one can specialize very early on, both in process and content. But I do think that for the purpose of flying the flag of promoting alternative dispute resolution, one should do so as a generalist and start off at the very least by taking yourself to be an artist, somebody who has a palette of many colors, who will use the appropriate color for the appropriate piece of work that they are producing. I think generalism in mediation, certainly at this stage, is important. And I think that simplicity is also the way in which to explain mediation, its intentions and its outcome to those who either do not understand it or wish to resist its charms. After all, what is it that we're talking about? Are we talking about a justice system? I've always been very much in two minds about whether mediation offers an alternative form of justice. And I suppose in many respects, it depends on what you mean by the word justice. It's certainly a process, but I think it's far removed from liberal concepts of justice. What we're talking about, of course, is a process which reintegrates relationships or finds pragmatic solutions as an alternative to justice systems which are based on legal rights. And if you take that as your starting point, then it's certainly no surprise that orthodox lawyers have difficulty with associating the manner in which mediation proceeds with the established rule of law principles that underpin the social contract between the citizen and the state. So I think that these larger and wider questions give rise to obvious reticence and reluctance by lawyers who trained in an orthodox fashion or who join firms as juniors only to be told by senior practitioners it's all very well, but it's really not something we do here. So I want to start really what I have to say in terms of analysis by looking quite a long way back. And I always take as a starting point when I talk to lawyers about mediation, the very famous quotation by Abraham Lincoln, who was preparing notes for a law lecture that he gave in 1850. And I think many of you will be familiar with this. But each time I read it, it reinforces my view that what we are trying to do is extremely important. And he said to the lawyers of his generation, discourage litigation. Persuade your neighbors to compromise whenever you can. point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough. No, I have to say, normally I stop there, but there are other bits of this wonderful lecture which I would encourage you to look at. And in particular, some of the stringent comments he makes about the lawyers of his day in the United States. He went on to say, never stir up litigation. A worse man can scarcely be found than one who does this. Who can be more nearly a fiend than he who habitually overhauls the register of deeds in search of defects and titles, whereon to stir up strife and put money in his pocket? A moral tone ought to be infused into the profession, which should drive such men out of it. There is a vague popular belief that lawyers are necessarily dishonest. I say vague because when we consider to what extent confidence and honors are reposed in and conferred upon lawyers by the people, it appears improbable that their impression of dishonesty is very distinct and vivid. Yet the impression is common, almost universal. Let no young man choosing the law for a calling for a moment yield to the popular belief. Resolve to be honest in all events. And if in your own judgment you cannot be an honest lawyer, be resolved to be honest without being a lawyer. Choose some other occupation, rather than one in the choosing of which you do in advance consent to be a knave. And that, of course, was before he entered politics, before he had any thought of running for the White House. So where do we start? I think the starting point actually, and domestically, and of course I will be contradicted if I'm wrong, but I think where we start is the Arbitration and Conciliation Act of 1996, which really introduced conciliation for the first time as a formalized process, legal process within India. And of course, Section 74 of that act gave a settlement agreement the same status as that of an arbitral award and executable like a decree of the court. And from there, fairly shortly afterwards, we came to Section 89 of the Civil Procedure Code, which by amendment of an act of 1999 came into effect in 2002. Practitioners who are long enough in the tooth will remember that Section 89 gave rise to a number of conflicting decisions in the various high courts of India until the Supreme Court handed down judgment in a case called Infrastructure Limited and Cherry and Barkey Construction in 2010, which set out important guidelines on the way in which the courts should deal with conciliation and indeed all forms of ADR. The real advance, I think, was probably 2015 in the Commercial Courts Act, which came into force in October 2015. It was really the first time that there was an element of compulsion in mediation in respect of commercial disputes with a value of greater than 3 lakhs. And here was the first element of compulsion, in the sense that there was a 2018 amendment which said that where a suit doesn't contemplate urgent interim relief, the plaintiff has to undergo pre-institution mediation. And this was really the start of lawyers engaging seriously in mediation in India, in my view. And of course, in almost all developing jurisdictions, and I use the phrase developing jurisdiction to refer to mediation rather than anything else, throwing a stone, quite a large stone, into a pond suggests that the ripples will come out first gradually and eventually to be fairly far-reaching. To the extent that there was sufficient consciousness of the importance and use of mediation, that India was one of the first signatories to the Singapore Convention in August 2019, the United Nations Convention on International Settlement Agreements resulting from mediation. And this really puts India at the very forefront of international mediation settlement enforcement. In the same way, of course, that it was a signatory and ratified the United Nations Convention on Arbitration in the New York Convention of 1959. I start there because I want to just quickly pick up on the other jurisdictions that I have mentioned, because I think one draws a very singular lesson from all of the jurisdictions to which I refer. I want to refer to my own jurisdiction in a very limited capacity, the jurisdiction of England and Wales. It has no regulation in respect of mediation. Civil and commercial mediation is and has always been unregulated. And although it started life, I suppose, in around about 1990, and I undertook my own training in early 1991, I think that what we have is a great reflection of organic growth. And organic growth tends to push people in a particular direction. And it is certainly true that people barely noticed the incidence of mediation for nearly 10 years. And it wasn't until the civil procedure rules of 1999 changed a process in the higher courts that people began to take note of the fact that the courts could stay proceedings for mediation, whether the parties wanted to or not. And more than that, we have a very expensive jurisdiction, as many of you may know, and we have a one-way cost shifting basis where the nominally, but certainly the starting point is that the loser pays the costs of the winner. And a refusal to engage in mediation led to threats of sanction by the court. That if one refused mediation, went on to win the case, you could put at risk a costs award by having done so unreasonably. And that, I think, was the first time that lawyers really sat up and started to realize that a failure to engage with mediation might prejudice their clients' costs. Now, I want to compare that very specifically with mediation in Turkey, where I have been working with the Ministry of Justice since about 2012. And although Turkey may be a jurisdiction with which you're not familiar, the reason I use it as an example is that Turkey has carried out a planned, centralized legal and regulatory framework since the enactment of the Turkish mediation law of 2012 came into force in 2013. Now, although this law introduced voluntary mediation to legal disputes, and it regulated the enforceability of mediation agreements, the ministry decided to take a leap of faith, and the secondary legislation that accompanied the Turkish Mediation Act regulated mediation to the extent that mediators had to be registered with the Ministry of Justice. They had to hold Turkish nationality, had to be lawyers of at least 5 years standing, they had to be working in the field of law in which they wished to practice mediation for at least 5 years. They had to complete a relevant mediation training program, which was delivered at a university. They had to undertake a state examination in mediation, and they had to be licensed, therefore, by the state. Now, having created this centralized regulatory system, the ministry embarked on a series of compulsory mediation laws. And they started off with what you and I would call workplace mediation, that is employer-employee disputes, which made mediation compulsory before one could then proceed to the labor courts in respect of employment disputes. Mandatory mediation came into force on the January the 1st, 2018, and 67% of employment disputes found their way immediately into mediation. And that was a little under 300,000 cases, which resulted in something in the order of 80% success in terms of settlement. At the same time, the number of labor lawsuits filed in the labor courts decreased by 70% compared with the same period in 2017. Now, buoyed up with this tremendous success, in December 2018, the Turkish Ministry of Justice decided to extend compulsory mediation to civil commercial disputes. And you would imagine that mediation, therefore, had taken off in a very substantial way and was recognized as a very successful process by the bar and by the lawyers. In fact, within civil commercial work, this extension turned out to be a disaster because the quality of the mediators, and I say this with some diffidence, but it became apparent very quickly that the quality of the mediators in dealing with employment disputes was not the same when they were asked to deal with civil commercial disputes. And the Turkish government is really having to rethink mediation in those areas, because it had planned to roll out compulsory mediation into family law disputes. So there is a new Mediation Act in Turkey. And it is the case that they're rethinking practical training, because academic training, as I think I stated at the very beginning, is not such that you would expect working practicing mediators to base their entire the foundation of their work upon simply academic learning. I'm pleased to also mention the Nigerian position, and I do see some friends from Nigeria who kindly registered for this talk. And of course, the excitement in Nigeria is that in May last, so no more than 4 or 5 weeks ago, President Buhari signed into law a new and groundbreaking Arbitration and Mediation Act, the 23 Act. And this effectively replaced the existing framework, which was an Arbitration and Conciliation Act of 1988. And commentators suggest that in Nigeria, this act has the power to completely revolutionize the dispute resolution landscape. And therefore, arbitration and mediation practitioners were extremely pleased when this came about. And a lot of commentators say this really is a watershed moment for alternative dispute resolution within Nigeria. the Act codifies the practice of mediation. It aims to foster the enforcement of international mediation settlement agreements by incorporating directly into the Act the Singapore Convention. And it means that international settlement agreements made outside the Federal Republic of Nigeria can now be enforced in any of the federal courts within Nigeria. And of course, at the same time, it's going to make Nigeria an effective international hub in respect of its arbitration work. Trying to draw on these various themes, and to do so, I need also to mention the position in Italy, where in 2011, the government instituted compulsory mediation in civil procedure. And the reason I mention Italy is because something rather strange happened there, which hasn't actually happened anywhere else, which is that in defiance of the requirement of the government that all matters should be brought to mediation, the lawyers went on strike, and they forced the government by using the Constitutional Court to reverse the decision on compulsory mediation in 2013. What the court engineered was that parties to mediation had to be represented by lawyers. And this was the first really demonstrative element of mass lawyer resistance to mediation in a proactive way. The situation in Italy has settled down somewhat in the decades since then, but it highlighted the impact of what it is that is the core question for today's discussion. And outside process, then I think it is important to consider what it is that lawyers are making of this gradual inroads into professional civil justice practice. And I do think that it's worth, therefore, taking as a broad context for this discussion the fact that in all of the jurisdictions that I have mentioned, lawyers have been conscious of substantive law and substantive civil procedure dealing with mediation for somewhere between 2 and 4 decades. And it is astonishing that lawyers still pretend that ADR and mediation is something new. It is not new. And in all of the jurisdictions that I have mentioned, my own and the 4 others, taken as examples, but now with developing mediation jurisdictions in at least 80 countries of the world, it is astonishing that lawyers are still resistant in those areas where they are. And to that extent, it follows that there are significant pockets where, taken literally, lawyers act as the foe of mediators and of mediation. Now, I probably put that perhaps too strongly, and I have been asked actually not to use the word foe, because I think it probably is pitching it a little high to say that the lawyer is the enemy of mediation. But I think that the areas of resistance are understandable. I think that the orthodoxy of legal professional training really has a significant impact on whether lawyers are going to be familiar with mediation and whether they are going to want to apply it in circumstances where it's plainly going to be of benefit to their client. So I see that if a mediator cannot justify to lawyer representatives of clients that mediation is a form of justice and it sits within the rule of law, then it's quite easy for a lawyer to be dismissive and to find objection in engaging in the process. Lawyers in binary systems of justice that are trained in the adversarial tradition find it difficult to engage in a non-adversarial process. And in particular, and I suppose it's rather crass to put it this way, but I've always discovered that lawyers who come into mediation with really no real grounding in what it is that they are supposed to be doing find it very difficult to be able to display to their clients how they are earning their money. And I think it is quite a simple proposition that because lawyers who don't undergo mediation training really don't know how to get the best out of the process for their client and gain the advantage that the process is there to deliver, fall back on the way they have been trained. They fall back into their adversarial skills. They see this as a forensic process, and they fail to understand that it is a completely different mindset that is required of the lawyer who engages in mediation with the hope of getting something better for their client. And I think in many respects, it's very simple. And it is simply one stage more than what the lawyer should ordinarily ask of his client when the client first engages with that lawyer. Traditionally, the lawyer does and should, in my view, always ask the client, what is it that you want? What are you trying to achieve? But actually, I think that there's another question which is equally important, and it's something that I tend to ask all my clients. And it's simply this, bearing in mind that the adversarial binary system in which we all have grown up is based on the protection, the defense, and the advancement of rights, the rights of the citizen, legal rights, civil rights, constitutional rights, whatever they happen to be, as part of the social contract. I ask my client, do you want to be right? Or do you want to be better off? And I think this is the key element for engaging in mediation. One of the things that civil process does to practicing lawyers is it offers us a framework within which to work. But that framework also operates as a constraint. And in particular, lawyers have the ability and the skill to be creative in problem solving. And yet it's not required of us. Because once we engage in the civil process, there's very little room to be creative because the remedy is prescribed by law, it's administered by the court, it's at the end of a process in which we, the lawyer, effectively knows how to engage by marshalling evidence, weighing the balance of evidence and law, determining the potential outcome. And it's almost like an industrial process. It's almost like a conveyor belt. And the creativity of the lawyer is suppressed. But mediation has the opportunity of releasing the lawyer from the constraints with which we operate to the great benefit of the client. And I would say to the benefit of the lawyer, because the lawyer can demonstrate skills which he or she has, which are not called on and which are there and which can put the lawyer in a a competitive position in the marketplace. Because the next problem that lawyers have in terms of being an enemy of mediation is that lawyers have this notion that ADR stands for alarming drop in revenue. And it's very difficult in developing jurisdictions to persuade lawyers that there will still be work enough in the context in which Abraham Lincoln was talking. And it's also very difficult to persuade them that this is a business model which can help them in terms of revenue generation. I think the answer is that it requires a medium-term or a long-term business plan to understand that mediation is designed to produce satisfied clients, and more of them, and speedier. Your satisfied client comes about because you're much more likely to get a satisfied client as a result of mediation than as litigation, simply because the outcomes that are available are what the client actually wants. And it is perfectly possible for the client to secure something of significant advantage, whether it's commercial, whether it's social, whether it's based on preserving and developing a relationship, without the necessity of being told whether he's right or wrong by an expensive arbiter at the end of many years waiting. That client is going to be your marketing device, because he will be telling other people what a wonderful job you've done as a lawyer. After all, the settlement is your achievement. Never mind the mediator, it's the lawyer's achievement. And a sensible mediator will give that reward to the lawyers. Why? Because the lawyers will bring the mediator the next case. So it makes commercial sense to do so. And thirdly, of course, you have all the benefits of the process, which pretty much everybody on this call understands in terms of time saving and cost saving, and creating a cohesive process rather than a divisive process. And God knows all of the societies that I have mentioned today require cohesive processes from the top down. So the other thing I need to mention is the lawyer is master of the universe. And one of the reasons I come across lawyers who feel they don't need mediation training of any kind is because they make assumptions about it as a process. And those assumptions include the fact that lawyers themselves are superhuman, and they are already imbued with infinite knowledge. I can see people on the call nodding in agreement with this. But I'm afraid in my experience, when it comes to lawyers who attend mediation without having had any prior experience or notion, that image of the lawyer falls a little short. I think that one of the problems is that lawyers see mediation as intellectually unworthy. And of course, they couldn't be further from the truth, because mediation requires you not only to know your case and the strength of your case and the ability to measure the outcome of your case against what is being offered in the course of the mediation, but it requires you to know a good deal more about your client than perhaps you would actually want to as a professional. It requires you to be your client's surrogate and your client's handholder and your client's social worker and a whole other gamut of things that perhaps you may not have decided you were going to sign up for when you became a lawyer. But I can assure you, it is an intellectual process which has the force of creativity that I've already mentioned. So under those circumstances, is the lawyer the mediator's friend? And it follows from what I've been saying that the lawyer should be a friend of mediation and necessarily should therefore be a friend of the mediator. You and the mediator have similar roles. You both wish to get a benefit for your client. You both wish the dispute to be ended on terms that are satisfactory. And you will both work together in order to procure this. The difficulty arises towards the end of that journey when there is a fork in the path, because the mediator's job is to secure settlement, but he or she has no interest in what the settlement is, except for the fact that it's durable. Mediators want settlements to last. But the lawyer has a different role, a different perspective, because the lawyer is concerned to get the best available settlement for the client. And the two are not the same. And at that point, the mediator may see the lawyer as an obstacle trying to defend client's interests, and the lawyer may see the mediator as somebody trying to get the client to cut a deal which is less than the client actually merits. And it's at that point that within the process, there are limits to the extent to which the lawyer can be a friend of the mediator and vice versa. Should the lawyer be a friend? Yes. The lawyer should support the process and apply it wherever possible, simply for the business case that I've iterated. The lawyer should engage with mediation to the extent of knowing what the law is concerning mediation, how to get the best out of the procedure in whatever jurisdiction you happen to be, how to apply it for the benefit of the client, even to the extent of exploiting the mediator, if that's what you think is necessary and what you can do. And in particular, you need the skill to be able to measure potential outcomes to the benefit of your client, to compare those with the outcomes available in the litigation process. And it seems to me that if you're capable of doing that, you will be a friend of the mediator, and you will be a friend of mediation, because you will engage in a way which forces you to embrace it. And I think that those really are the ways in which we should address this simple question. I know they're wide-ranging, and it may be that you didn't expect me to move in that direction when we started. But I want to thank everybody for participating in the talk today. I came to mediation at the very beginnings in the United Kingdom. And this year I'm celebrating my 30th anniversary as a mediator. I've worked in India for about 6 or 7 years, both in Goa and in Delhi. And I worked primarily with the Indian Institute of Arbitration and Mediation, running courses in mediation advocacy. And funnily enough, I'm running a course tomorrow, tomorrow, Friday and Saturday, by Zoom remotely in Delhi. And there are, I think, some places available. What I have done at the very beginning of the chat for this session, I put in some links, because it seemed to me that, first of all, in order to thank you for your courtesy in being interested in what I have to say, I I have some gifts for you. I want to be practical. The first gift is simply this. In 2007, I created a practice group called the SCMA, Standing Conference of Mediation Advocates. It seemed to me that it was important for lawyers to obtain formal mediation training, but also to have a forum where they could discuss matters of interest in mediation, not from the perspective of the mediator, but from the perspective of the lawyer representing the client. So my gift to you would be 6 months free membership of the SCMA. And I've put the link to that at the very beginning of the chat. But I have another gift to you. To celebrate my 30th anniversary as a mediator, I started an information project with a firm of publishers. And what I didn't see anywhere, including Amazon and eBay and places like that, I didn't see anywhere a single source by way of a bookshop carrying all or as many mediation titles as were in existence around the world. And I've persuaded a firm called Mediation Publishing to gather together from publishers around the world as many mediation titles as we could find. And we now have, I say we, they have something like 300 books and articles available on their website. And once again, I have put in the chat links to this site, but more than that, anybody that's registered today and the Nivaran organization, I have arranged with this publisher to provide you with a discount on both hard copy and digital publications. I think there are about 300 on the site at the moment. And also in recognition of your kind attention today, I have a small gift, which is an article that I've written on the transformation of lawyers within mediation, from becoming sort of competitive within the adversarial process, and how the process makes you collaborative and creative. And that is my gift to you. And there is a link directly to that in the chat site, in the chat for this session. And it will take you directly to that as a free article for you. I think that what I've had to say has probably been too broad-ranging to have been the focus of some of your more specific questions. And so I would be very pleased now to answer questions from the many jurisdictions that I can see listed in the participants. But I do thank you for your very kind attendance and attention.
Excellent, Andrew. Yeah, you have opened up the window for us to see the different degree of acceptance or rejection of mediation or the ADR process services by different jurisdictions in different countries. Definitely the awareness about the ADR-ODR process is to be scaled up, along with creation of a mediation mindset. As you said, mediation advocacy is the need of the hour. With your permission, could I now take up the questions from our participants? But before that, I would urge you to please enlighten us, and for our young participants also, with your thoughts about the prospect of our young professionals who want to take up ADR-ODR as a career, and what are the steps they should take regarding this. Because they keep on questioning how to go about it and how is economically, financially, it is sustainable. That is the moot question, I think.
Can I answer first of all from the perspective of the mediator? When I when I became a mediator, I was told that in order to be a successful mediator, you needed to have either grey hair or no hair. And I now fall into that category. In fact, actually, I fall into both categories. And I came across a lot of commercial mediation service providers who are encouraging young people to become mediators. And this concerned me because I wondered at that time whether or not this was really a good idea in terms of cost benefit for young people who are going to be encouraged to spend a lot of money getting a qualification, which might not lead them to a business. But the providers would say, well, you've got the skills and you can apply the skills in your mainstream practice, and you can mediate more and more as you get more senior. I've come round to the idea that there is a place for young people in mediation. And I know that by looking at my own children who are in their 20s and 30s. The fact is that I belong to a generation that uses English in a very different way to the way that my children use English. And sometimes I have difficulty in communicating, and sometimes I even have difficulty in understanding the conversation which they have with their peer group. Now, it seems to me that disputes sitting within that peer group, within young people who are specifically concerned with perhaps disputes arising out of technology, innovation in business practice, entrepreneurship, and issues, for example, affecting students, I see no reason why they shouldn't select a young mediator who would have access to the same knowledge of technology, the same knowledge of young entrepreneurship, and have much more of a feel for the things that are important to them, rather than effectively a white middle-class lawyer who has his place, but whose place may be limited to my generation. So I think there is room for young people coming into the profession of mediator. Whether there is sufficient business, I cannot say. I think mediation as a field is expanding. It seemed to me to be incumbent upon all mediators to try and expand the market by talking about mediation to business groups, to community groups, to anybody that would listen, to be perfectly honest. And I do think that around the world, we're going to be seeing more and more compulsion in getting people into mediation. Obviously, taking a horse to water doesn't mean you can make it drink, but at least getting it within the environment of the water means that a good mediator will have a chance to get the parties to listen and settle where they can. And I do think, therefore, that as the market expands, business for mediators will expand. I think that it's important that you go to a recognized provider and not simply a commercial exploiter of young people, or indeed anybody. I think that it is still mainly a lawyer's game, although I have myself trained medical staff, clinicians, construction professionals, and accountants to be mediators. And I have no reason to suppose they don't do as good a job as any lawyer. I do think that it's important to find a mentor, or at least have access to experienced practitioners that they can watch. I do think that that they need to understand that mediation is a reflection of personality, and they need to have the personality to do it. They need to have the confidence to do it. It's not going to be the same for everybody. It will require perseverance. It will require doggedness in order to succeed, and it will take time. So far as mediation advocacy is concerned, I coined this term in 2005, and I've been promoting it ever since. and of course, in the early years, I was told you can't have mediation advocacy. It's a non-adversarial process, and therefore the term itself is an oxymoron. I don't agree. I think that, firstly, there is no locus standi in mediation. Anybody can represent a party in mediation. And the lawyers need to recognize that if they don't skill up in mediation, there will be other professions that come along and take away the work. And I'm quite serious about that. I cannot for the life of me understand why the accountants haven't jumped on this already and taken a large proportion of the market, because they see their clients every year. And at the moment, they seem to think that if their clients get involved in a dispute, they have to give them away to a lawyer. Once they wake up to the fact that mediation means they don't need to give them to a lawyer, they'll keep them for themselves. So I think mediators should recognize that there'll be other kinds of people in the room who are representing parties who are not lawyers, and they may very well benefit from that outside experience. I do think that representing a party in mediation, as I've already said, requires a different skill set as well as a different mindset. And I really do think that lawyers should take the time and trouble to attend some formal training in mediation skills, if not formal mediation advocacy. I do think that it's an expanding market, because fairly obviously, as the market for mediation expands around the world, so the market in representing parties in mediation will do so as well. It is not, there's plenty of literature on the subject. It's not a million miles away from representing parties in any contentious business. And I therefore would encourage people to do that. But having said that, I think that there is an important place for lawyers who are engaged in non-contentious work to become involved in mediation advocacy. Because lawyers who act in property transactions and commercial conveyancing, these are the lawyers who are used to doing deals. They are the lawyers who are used to speaking to the other side, and they are lawyers who are used to understanding the need to make concessions and what to look for. They are more skilled in negotiating. And I think that the place of the lawyer as mediation advocate coming from a non-contentious background is going to be much more advantageous to clients, because I think they will secure better outcomes. And for lawyers in large firms who are in a non-contentious department, it means they don't have to give their clients away to the contentious department, the dispute resolution department, where there is a risk of losing the client to the firm if they lose the case. So I think that there is a significant area for development by transactional lawyers, non-contentious lawyers.
Thank you, Andrew. Many requests are coming for resending the links you have already posted in the beginning, so that participants can be benefited.
I'm just, can people not just go right to the top? Here we go. So at the very top of the chat, I put in the link to SCMA, and then I have the link to mediation publishing immediately after that at the next one in the chat. And there's another one there, which is the other discount link for mediation publishing. And I think below that, I've put in the link to, there's the link to the Indian Institute of Arbitration and Mediation for mediation advocacy training. So all of the links are at the very top of the chat.
Maybe you can put them again, Andrew.
Aruneshwar, I think now you should take over.
Thank you, Sangeeta.
Because there are so many queries, we can take them.
This is a question. Andrew, this is a question which is raised by one Nishta Single. And the question is, would a lawyer who has not yet started practicing law make a better mediator than the one who has a litigating experience?
I think that in theory, there is no reason why a non-lawyer cannot mediate perfectly well. And under those circumstances, it follows that the new lawyer or a lawyer who has not got experience in contentious work should also be able to mediate well. If you're talking about comparison, the answer, a good legal answer, it depends. You know that many of the disputes that come before mediators are either based on contract or tort or property. And under those circumstances, I think a lawyer acting as a mediator will find it much easier to understand the context in which the dispute arises if they have both grounding and experience in at least those three areas.
Thank you, Andrew. There's another question from Savio Travaso. And the question is, how can lawyers and mediators be trained in specific skills required for the respective areas of practice, so that there is a clear space for mediation and for litigation advocates for a specific skill?
Yeah. I mentioned near the beginning of my talk that I think that one approaches mediation as a generalist, but in fact, specialist areas are continuing to embrace mediation around the world. And in particular, organizations and institutions are creating their own standalone mediation schemes. I think I've probably made too much mention of court-annexed, court-directed or court-appointed mediation, whereas the majority of mediations still occur in the private sector. Within the private sector, there are specialist areas of legal practice where mediation schemes are being created. At the moment, the European Union's Intellectual Property Office is about to launch a specialist scheme which will be concerned with patent disputes. Those of you who are familiar with the nominet, with the domain names providers at various different levels, nominet have mediation schemes. I'm aware of private landlord and tenant mediation schemes that are run by housing associations and local authorities. There are private mediation schemes that bar associations create around the world. So, for example, my own practice group, the Professional Negligence Bar Association in the UK, we run our own mediation scheme. On the fringe of that, you have organizations setting up adjudication schemes. We have Court of Appeal mediation schemes in many jurisdictions where the focus of the appeal is much more likely to be specialist than generalist. So it seems to me that there is nothing incompatible with being a specialist practitioner and becoming involved in mediation within your specialist area.
Unmute, Sangeeta, you have to unmute yourself.
Sorry. The question is from Himadri Basu, a law student. The question is, what are some common misconceptions or stereotypes that people have about mediators and how these can be addressed?
Well, I find it difficult to answer this. I don't see mediators as stereotypical. I see mediators as highly individual. it seems to me that once people are engaged in the mediation market, they look for the particular skill set of a mediator beyond the fact that they are an experienced mediator. So they look at the kind of person they want to deal with their dispute or their client's dispute. And they look at their background and they look at the way they approach mediation, whether they're going to be interventionist or robust, or whether they're going to be laissez-faire and allow the parties to get on with it with a light touch intervention. I find it difficult to think of any stereotypical mediator, I'm afraid, unless I am one.
Aruneshwar, will you be asking the question, or should I take up one more from Myrna Douglas? She's asking for a database. Is there anything available on the success rate of mediation so that it would convince the young lawyers that they can take up mediation as a career?
I'm assuming that we're talking about mediation advocacy rather than being a mediator. So far as I'm aware, that there are only very limited databases. The International Mediation Institute has a database of mediation advocates. It's very small. They are trying to expand. The SCMA is trying to expand. Unfortunately, COVID savaged our procedure. The moment COVID struck, I took the decision to stop subscription fees. It seemed to me that people had enough troubles without having to pay subscription to a professional organization. And I thought most professional organizations would take the same view, but obviously not. But having effectively cut off our own funds, it's taken us a while to recover. So we certainly have a database of members. We can only publish such material as we can in accordance with the General Data Protection Regulations. But I would have thought that certainly within the next few years, it will be common to see people describing themselves as mediation advocates who appear in the normal directories.
Anju, there is another question. Okay, Aruneshwar, go ahead.
There's a question from Smita. She says, we have a huge backlog of under trials languishing in jails for petty offenses. Can the mediators be trained to handle such cases? Or the other issue is whether the criminal cases can be referred for mediation.
Okay. It seems to me that mediators who are trained in restorative justice can undertake this work, but it takes a political will to change that part of the system. I'm aware of at least two mediators who specialize in restorative justice. It's developed in a number of states in America. It is a growing phenomenon.
Yeah, I'd go for it.
The problem, of course, is public confidence. Very difficult for the public, the wider public, to have confidence in restorative justice. And I think they're looking for evidence that it works at the moment. I think it is something for the future. I do think that it should be tied to, it doesn't necessarily stand alone. It can be tied to another sanction that the criminal justice system has available. But I do think that mediators are perfectly capable of being trained in RJ in order to help clear up the number of petty criminals that are currently locked up.
There is a question from Peter Gesh. He says, in your experience and listening to your questions that you ask client, do you think courts should recommend mediation as a starting point in seeking justice?
I think the example that I would point to is the Lagos multi-door courthouse. And indeed, there are multi-door courthouses in I think 8 states now in the Federation of Nigeria. I think that the process where the court itself considers the papers on issue and determines whether mediation is suitable and then puts it out for mediation is a very useful function of court administrators. But they should only do it if they know exactly what they are looking at. I mean, I wouldn't want a court to be able to do that simply to reduce their list or to reduce the cost to the Treasury of a lot of business coming into courts. I think that if the court is going to say, yes, we think this is worthy of mediation, that decision needs to be trained by somebody who knows what mediation is, and it should be decided on legitimate grounds.
Ms. Alka Singh, advocate from High Court of Delhi and Supreme Court, she's asking then, do the cultural differences matter in the light of mediation trainings and workshops all around the world?
My experience would suggest that cultural differences are extremely important, and that mediators need to have regard to the people who are appearing in the mediation, particularly the clients. But I come from a background where within our jurisdiction, we effectively do operate in a multicultural way. I also travel the world, and therefore I'm very sensitive to meeting the needs of cultural differences which may sit underneath the dispute. And of course, as a British lawyer, I represent the arrogance of the West.
And there is another question. What, Aruneshwar, are you taking up? You can. Okay. What needs to be done as a process in case of disputes between parties to allow for distinct markets for mediation and litigation? Distinct markets for mediation and litigation.
I'm sorry, could you repeat the question?
Yes. What needs to be done as a process in case of disputes between parties to allow for distinct markets for mediation and litigation?
Okay. So to an extent, it requires political decision-making, or at the very least, it needs judicial decision-making to institute substantive regulation to divide up markets along these lines. Now, within the UK, there is a markets authority which can designate certain areas of commerce and business as areas where all disputes must go to mediation first. And
okay,
when
let's take the last. This is a question from Robert Gutwa, and I think that's a very interesting question. He says the question is schools, and I would say institutes or people who are conducting trainings, mediators training, they also need to be certified, now how can they harmonize all mediators worldwide? Because you don't know that you are getting training, whether the institute which are imparting training, because you will have a lot of shops coming up. So whether there's a certificate.
That means an umbrella body, sort of say, which is yesterday we were talking. Yes.
Let's see what's induced take.
There are very few jurisdictions where training is regulated either by the state or by bar authorities. I think firstly, where the state imposes regulation upon mediators, the state should license the providers who are giving training. Where the state doesn't regulate mediation, it should be incumbent upon the professional authorities, whether it's bars or law societies or institutes of accountancy or institutes of surveyors, whatever the institution is concerned, they should impose self-regulation upon service providers who are providing training. There is no consistent standard across the world, which is why the International Mediation Institute was set up in the first place. They devise standards and they have effectively licensed organizations to provide training in a recognized way around the world. Organizations such as the IIAM, the Indian Institute for Arbitration and Mediation, provide recognized courses, as do APCAM, the Asia Pacific Centers for Arbitration and Mediation, as I have no doubt do you. I don't know whether Nivaran provides formal training in producing mediators. You need to look for an organization of real substance that's doing this rather than a commercial provider. If it's a commercial provider, they need to be a service provider that's actually undertaking mediations as well as simply undertaking training. And I do think that you have to be fairly careful. I can remember I did a course in Goa in 2015. And to my astonishment, I suppose I shouldn't really have been surprised, a couple of the students took my notes and set up their own training company within about 2 or 3 weeks afterwards. How their delegates, what would have happened if their delegates had asked them about their personal experience? I have no idea.
So, Aruneshwar, are we having time for taking some more questions? I cannot see. Because...
Yeah, I don't see much questions coming. One last question, Andrew. Maybe that's a question for me.
Yeah.
What do you think about the, with the impact of the post-COVID issues? The online mediation, the online courts and online mediations are in a big way. So, what do you think the dynamics? Two questions. One is on the dynamics on online mediation. And other is what is the real resistance to the mediation coming up? Online mediation.
So, I think that as the pandemic developed and it became obvious that it was going to last a lot longer than people realized, people were driven to engage in online mediation in a way they hadn't before. I think for many people, they regard it as cost effective, that the disadvantages were not as great as they feared, and it's a perfectly effective means of mediating disputes. On the other hand, I had clients who were waiting to physically see me for a very long time and were prepared to wait. And I think that now it's simply a facility that the clients should choose. I think that the market in mediation will have been enhanced very considerably by COVID because of the nature of disputes which have arisen. So, for example, our courts are clogged up in landlord and tenant disputes arising out of claims for rent payable to commercial landlords at a time when lockdown was going on and the tenant wasn't making any money. And under those circumstances, it seems to me that you will inevitably have claimants who have legitimate claims, but who may push defendants into bankruptcy simply as a result of the economic circumstances arising over the pandemic period. And I think the great advance in mediation is the fact that mediators can help the parties renegotiate their contract in order to secure an outcome, because courts cannot. A court can make a judgment, find fault, and declare a remedy. But I haven't come across a court in any jurisdiction that's prepared to intervene and help the parties renegotiate their contract in order to determine how loss should feed through a trading relationship. Under those circumstances, I can see tremendous potential growth in mediation caused by the pandemic. And I do see that online mediation will be consistently high now. And I suspect that there will be an adjustment, a balance. But I rather think that we will have perhaps 50 to 60% online mediation as against 30 to 40% live mediation, developing as a pattern from now on.
Aruneshwar, you have any more question? Because
I think
all
we must. It's time to close now.
Actually, all queries raised here, Andrew, could not be taken up today. I think most of that we have already taken up. But I believe Nivaran will continue giving us all further opportunities to interact through such events in future. And it is wonderful to have you today, Andrew, in this great session. From Team Nivaran, we express our heartfelt gratitude and thanks for your time today. Over to you, Aruneshwar, for the vote of thanks formally.
Thanks to Professor Andrew Goodman for such a great articulation and a wonderful discourse on a very interesting and a meaningful topic. It was a great treat to hear him during the question answer sessions. I totally agree with Andrew that there is stiff resistance by lawyers to mediation. But I think that is natural. As the disruption has really started now, and the disruption in technology, the disruption in thinking, the disruption is all over now. So we are just moving into a new dimension, and that changes will bring up the new energy. And I'm certain we'll move into the mediation era from the pure litigating era. So the shift is choiceless and will be adapted by lawyers in due course of time. Particularly when I see a whole class of lawyers who are in mediation, they have an intellectual involvement, there is an economics, there is a meaningful social contribution. And I think above all, there's a great satisfaction at the soul level. And I see a lot of women mediators coming in, and it's a very, very big way. And that is a very, very important phenomena which is emerging. For 4 years, 21 webinars and almost 500,000 views have been a great way forward for Nivaran. And I must tell Andrew, with Nivaran, we are conducting summer schools, we are conducting a lot of programs and also training programs. The mediators of Supreme Court, as they continue to take baby steps and strides in formation of a great institution. On the platform of Nivaran, we have heard Supreme Court judges, QCs, KCs, senior advocates, and many who have left to become full-time mediators, like Andrew Goodman today. It was always a great pleasure and privilege of hearing them all. It was such a great opportunity to be with Professor Andrew Goodman and hear his thoughts and concerns, his journey as a mediator, and how he has seen lawyers as foes moving and changing to friendly mediation system. I agree with Professor again, the concerns about the change, which may not be quick, and this is not a stopgap arrangement or a knee-jerk reaction, but change of social dynamics, perception, attitude, aptitude, and a way of thinking and life. Judges, arbitrators, and mediators are independent third party to whom litigants approach to resolve the disputes. Lawyers help their clients to win the litigation. And in this process of helping the clients to win, the lawyers continue to use all tools available to them, procedural, factual, and legal. And that is what I think Andrew was saying, that they try to be, they want to be litigating. So the litigation comes to be in their system. They enjoy that part of being in the court and litigating out and, try to win. Not only they try to tell the other side that, look, I am much more intelligent than what you are. So this is a process. And ultimately, it is, but at the end, the whole process of litigation and dispute resolution may lead to more damages and injuries to business and relationship than the dispute itself. And that is where the mediation comes in. So the litigant finally gets exhausted in terms of time, energy, and money by the end of the judgment is delivered and the execution of decree is affected, and develops a deterrence with the whole judicial system. And that is where the reaction comes in. Wow, this judicial system doesn't really serve me a purpose, but it is really fleecing me out. So litigation thrives on lawyers' ingenuity and ability to win cases, not what finally happens to the litigant, business relationships, and the society as a whole. And I think there's a big issue for mediation to step in. The judges and arbitrators adjudicate or decide according to law and facts on the records and pleadings and evidence, and leaves to the party to suffer or enjoy the impact of the judgment or the award. And as Andrew said, 80% of people are factually dissatisfied from the litigation. One party wins and one party loses in the final verdict. Mediators, and that is my take, mediators, unlike judges and arbitrators, do not adjudicate. They help litigants to resolve the disputes and at times the basic conflicts which led to the dispute. They help the litigants resolve their disputes. It's a win-win for both. That is one big reason why a huge number of litigants are ready and willing to join the mediation environment. There is an imperative need for a mediation bar. And that is where I make a very clear line that there are litigating lawyers and there are lawyers who would love to mediate between the parties. Now, this is an imperative need of mediation process. And that is where they become friends rather than being the foes. Advocates who are willing to help litigants undertake mediation and get back to business and meaningful life. Lawyers who are friends of mediation and not foes of the mediation. Fees for the lawyer is certainly an important. Now there's the economics. Being a lawyer is their profession. They earn their bread, butter, and lifestyle from it. It is a great misnomer and misunderstanding that mediation lawyer earns or will earn less than the litigating lawyer. If the fees of the lawyer is fixed irrespective of the procedure adopted for resolution of the dispute, this issue becomes irrelevant. Litigants, like patients, are willing to pay for services, but services has to be meaningful. Conflict, disputes, and litigation have no place in a civil society driven by cultural values and moral belief systems. They are aberrations in a society. A litigating lawyer who thrives and survives by creating chaos, conflicts, and confusion is certainly a foe to the mediation. But a mediation lawyer whose aim is to create harmony, resolve not just dispute, but the conflict itself by a generative dialogue and communication, squeezes out the confusion, is a great friend of mediation, litigant, society, and the mankind. The credit of mediation global, and that is what my take is, why it is certainly, people are aware is the 2018 UN resolution and the mediation and the 2019 Singapore Convention, which really put a seal. And that is the shift that we are looking at. And this is all part, according to me, the part of the paradigm shift to the fourth industrial revolution, the globalization 4.0, and rise of a civil society. Finally, I thank Andrew again for being with us. Thanks to everybody and all who have got from their schedules and are here for being with this on the evening of India, morning, afternoon, and night elsewhere in the globe. And we are looking forward for the 22nd webinar to be hosted by Nivaran soon. Thank you. And finally, I thank Santhan Krishnan, who is the soul and spirit of Nivaran. Thanks to Rajiv Datta, Senior Advocate, Rakesh Khanna, Senior Advocate, Jiten Sharma, Senior Advocate, the eyes and ears and arms of Nivaran. And finally, my thanks to Rahul Singh for running the show. Thank you all.
Thank you. Thank you.
So with this, I think, Santhan, you have some